So just be mindful that everyone should be mindful of that. Don't disclose personal information. If you need to, let us know and we can figure something out. But usually it's not too hard to avoid. Okay, we're ready to start recording. This is an original petition in suit affecting the parent-child relationship with an acknowledgement of paternity. This was filed by the Attorney General's Office February 4th of 2025. All parties are present on Zoom today. This is a remote proceeding. I am sitting outside of Waller County pursuant to the Family Code Section 201.1045. And I find nobody has objected to proceeding this way. Mr. Hernandez, can you state your full name for the record, please?
Juan Jose Hernandez Arizmendi.
Thank you. And Ms. Anzores, can you state your full name?
Cristina Adriana Anzures Vázquez.
And counsel for the custodial parent, can you state your name, please?
Lauren Bunch for custodial parent and cross petitioner.
Okay, thank you. And Ms. Azores and Mr. Hernandez, can you both please raise your right hands to be sworn in? Do you each solemnly swear that any testimony you give today will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, thank you. You can lower your hands. And counsel for the Attorney General's Office?
Julie Kahn.
Thank you. And where are we on this matter?
Judge, we had temporary orders back in October. There was a de novo in November, which modified it very slightly. Today we have an agreement as to the child support. We are going to leave it the same as under the temporary orders, $222 a month starting November 1st, and $50 a month in medical support with government medical also starting November 1st. And conservatorship and visitation and family violence and a drug test are all contested.
Okay. And just so clear, there's no issue with back child support.
No, Your Honor, they're not requesting retroactive or back child support. So
what was the medical is being provided through mom, right?
yes,
And that's through her job?
no, through Medicaid,
Medicaid, okay. What was the reimbursement again?
$50.
Okay. Okay, you may begin.
Judge, I was going to let Ms. Bunch begin to deal with the family violence and soul management.
Okay, you may do so.
Thank you. I'll call my client, Christina.
Actually, before we do, I just want to know, did any of the visitation that was ordered happen?
No, Your
Or
Honor, my
dispute?
client registered fully. We do not have record of Mr. Hernandez registering and no visits occurred.
Okay, you may proceed.
Thank you. Ms. Anzores, please state your full name for the record.
Cristina Adriana Anzures Vázquez.
You and Mr. Hernandez were previously in a dating relationship. Is that correct?
Yes.
And you have one child together. Please state that child's full name and current age.
Fabian 14.
So he is currently 11 years old. Is that correct?
Yes.
And at the time that this suit was filed, you had lived in Waller County for at least 6 months. Is that correct?
Yes.
Has she since moved? Just so I have an idea of where she lives?
No, she is still in Waller. Mr. Hernandez is located in Harris County, which is how they were eligible for the previous visitation order.
Okay.
So Ms. Anzores, when did you and Mr. Hernandez end your relationship?
That was February 5th of 2024.
And did you cease living together at that time? You separated, moved out of the home?
Yes, I moved.
And since you separated, who has Fabian primarily lived with?
Mom, me.
Since you separated, what is the longest period of time that Fabian spent with his father without you present?
24 hours.
And when did that occur? When was the last time he had a 24-hour visit?
That was on June 2024.
And when you went to pick Fabian up from that visit, what, if anything, occurred?
Well, his dad was intoxicated. He was not able to find Fabian's shoe, and I got in the house to look for the shoe, but his dad was angry at me and started telling me to get out of the house in a rude manner.
When, if ever, did he put his hands on you on that day?
On the shoulder, like move.
Okay. So he was pushing you?
Yeah, he got my shoulder and then he like, get out.
And had he ever put his hands on you before then?
Once he slapped me.
Do you remember when that occurred?
That was when we just moved to Katy and we got a new apartment. He went out and spent all the night out. And at 5 p.m. when he came back from home, I told him that I felt not respected for doing that, and I moved my hand towards him and he slapped me.
And do you remember when that occurred?
Not really that day of the month, but I just remember that we just moved to the new apartment in Katy.
And what year was that?
That was 2019.
Okay. So the June 2024 incident, has Fabian had any visits with his father since that date when you picked him up and his father pushed you?
Yes, but his grandparents were around.
Okay. Have there been any visits that Mr. Hernandez has had that were not supervised?
No,
And since that June incident where he appeared intoxicated to you, well, let me ask you this. Why do you think that he was intoxicated on that day?
because he was not able to communicate. He was like, at first when I look at him, I'm like, where is Fabian's shoe? He was like, I don't know. And then I tried to go into the house and then he slapped out and he's like, get out of the house. And so I just didn't want to argue with him and I got out of the house because I know he was intoxicated. Because I couldn't tell on his face and his movements and all that.
And following that June incident, did you become aware of any criminal charges against Mr. Hernandez?
Just because you told me the last court that he was in a DWI, I was not aware.
And Your Honor, I would offer, at this time, let me offer counter petitioners exhibit 1, which is our relief requested.
Does anyone have any objection to counter petitioners exhibit 1?
No objection, Your Honor.
Mr. Hernandez,
Yes.
what is your legal objection?
Nothing. Yeah, I mean, I would like to, whenever it's my turn, I would like to ask a couple of questions to Ms. Sensi.
Okay, you'll get that. Right now, I'm asking if there's any legal objection to admitting their exhibit 1. Okay,
No.
counter petitions 1 is admitted.
Thank you. Your Honor, I would also like to offer counter petitioners exhibits 3, 4, and 5, which are all certified copies of the misdemeanor charge for driving while intoxicated, bond condition violation report, which is number 4, and number 5 is the judgment of conviction on that charge.
Okay, does anyone have any legal objection to 3, 4, and 5?
No objection.
Mr. Hernandez?
The only objection that I would like to explain whenever it's my turn. That's it.
Okay, you'll get a chance, sir. Okay, the exhibits are admitted. As a practical matter, Ms. Khan, I don't know if you remember, I usually use Case Center when there's voluminous exhibits, so I can see them. And I really, hopefully, once you get fully staffed, want to get you all using it regularly. Right now, I don't have access to these. Are they filed? I don't believe I have access to the documents.
I cannot file, but I did. I can share my screen. I was about to ask if I may share my screen to display them.
Do you have copies, Ms. Khan?
I do not.
I may have forgotten to email those, and I apologize. Let me get those emailed over.
Do you remember how to use Case Center? Because we could create one for you, I think.
It's been a long time, and
Do you still have access to it?
I have no idea.
Okay, the exhibits have been sent to Attorney Khan, and would you like to wait for her to receive them, or do you want me to proceed with sharing my screen?
No, I find sharing screens. One, this sounds like it might have information we don't want on YouTube, so I'm concerned about that too. It's really hard for me to get everything I need from a screen share between the size and then sometimes as you ask more questions, you've taken it down. It's just very not, when it's voluminous documents, I just find it very ineffective. So bear with me. I'm going to try and create a Case Center and see if it works. It's going to take a while, guys. This is
Trying to log into it to make sure.
okay. And I'm trying to create the case. I just got distracted answering that question. So, and I don't have a template for y'all because we use it so rarely, but we will create templates soon.
Account has been locked out due to inactivity.
So I'm going to try and create one and see if you get the because I don't think you need an account to do some of this stuff, so we might do it that way. Just bear with me while I create the exhibit, because this is,
Yeah, it says I've been unlocked. Okay, we'll see. It says please select a section. I don't know. what
oh,
that-
do you have to do that, or can you just, is there a place to just upload documents? Because you shouldn't have to do all that.
It says upload files, and then I've got them put in, and then it says
Okay.
select files.
I think after you put them in, you can just click on upload. If it makes you click a section, does it give you options?
No, it just says please select to add a section, and then section.
What are the, is there like an empty box after that, or does it let you like a drop down? Like it has to have something to select.
Can I share the screen? I don't think this shows anything
Okay.
crazy. I mean, it doesn't show anything. It's just this is what it's telling me. So I've got.
Oh, just say update all documents. Click on that and see what happens.
See, it won't let me do it. It like does a thing.
Oh, go to that drop down. The please select a section drop down. Huh. And that's the only option it gives you?
I know, it doesn't.
Maybe click just import bookmarks or whatever
I don't know.
and see if that does it. Oh yeah, add files. That might be it.
But that's wanting me to add more stuff,
Yeah, no, that's not it. Start upload.
and I've hit that multiple times, and it's not doing.
Go back to the key.
I think that's going to delete it. Don't know why it's.
Other way to get you this.
Let me see if it'll.
3, 4, and 5 got admitted.
Yes, Your Honor.
Okay. Okay. Counter petitioners 3, 4, and 5 are now admitted. You may continue.
Thank you, Your Honor. Permission to share my screen?
You may share.
Thank you. Ms. Anzuris, I'm showing you what has been marked and admitted as counter petitioners exhibit 3. This is the misdemeanor charge against Mr. Hernandez for driving while intoxicated for an incident that occurred late 2024. Is that correct?
Correct.
Yes.
And sir, it's Ms. Anzores who is testifying right now.
Yes, I see it.
Okay.
Yes.
And Ms. Anzuris, I'm now showing you what has been marked and admitted as counter petitioners exhibit 4. This reports that following that incident, he had a violation that occurred while the charge was pending. That was reported as a bond condition violation report. Is that correct?
Correct.
Okay. And finally, that in fall of last year, as this case was in progress, he was charged or he was convicted of the DWI on September 11th, pled guilty to it. Is that correct?
Yes.
Now, you testified you'd seen him intoxicated before. Are you aware of him using any other illegal substances or drugs?
Yes.
What did you know him to use?
Cocaine.
And how often would he use that?
Every day if he could, or 3 times a week.
And this was when you were together that you were witnessing this. Is this correct?
Yes.
And when he was on that substance, do you believe he was in a condition where he would have been able to care for Fabian?
No.
Now, did you ever use cocaine in the past?
Yes.
Okay. And why did you use it in the past?
To have intimate relationships with my ex-boyfriend, ex-father of my son.
Okay. And you're talking about Mr. Hernandez or a different gentleman?
No, just him.
Okay. And was that something you wanted to do, or was that something he asked you to do?
He asked me to do, and I did it because that was the only way I could spend the night with him.
Okay. When was the last time this occurred?
December 2023.
Of 2022 or 2023? I couldn't understand you.
2022.
And have you used any illegal substances since then?
No.
Okay. And do you have any plans to use them in future?
No.
Do you have any reason to believe that Mr. Hernandez would have continued to use those substances?
Yes.
Why?
Because I asked him to quit and he just didn't want to.
And let's confirm some details about Fabian as well. What diagnosis, if any, does he have currently?
He has autism He's autistic. He is not able to communicate.
Okay. How far is he able to communicate? Does he speak in words or complete sentences?
Only the words that he knows, like restroom, food, drink.
And is he currently enrolled in any special programs or schools to assist him with that?
Yes.
Okay. Don't say the name of the school, but is it a program or a dedicated school for autistic?
It's a program for special needs kids. It's called YCAP. He also has occupational therapy and speech therapy and echinotherapy.
And who is currently managing those therapies, getting him scheduled and to and from appointments?
Who manage?
Who is handling those appointments for him? What adult is with him?
Oh, I am the mother. Yeah, I done it from day one that I.
So today in this court, are you asking to be appointed sole managing conservator of Fabian, given the history between you and Mr. Hernandez?
Yes.
And are you asking to confirm the visitation previously ordered by this court to begin and supervised unless or until Mr. Hernandez is able to test clean on a zero tolerance hair follicle drug test and urinalysis?
Yes.
And you're asking for the same step-up provisions that were ordered by this court for temporary orders in the event that he tests clean, proceeding to single overnight visits through 3 stages. Is that correct?
Correct.
And those are laid out in Counter Petitioners Exhibit 1. Now, Ms. Enzores, let's confirm under the temporary orders, y'all were ordered to the Harris County Domestic Relations Office supervised visitation program, correct?
Yes.
Did you register for that program?
Yes.
Did you complete all required paperwork and any interviews that they required to begin visits?
Yes.
Were you ever notified by them that Mr. Hernandez had completed his registration?
No.
Did they ever contact you to confirm any scheduled visits?
No.
So Mr. Hernandez has not completed any visits with that program to date. Is that correct?
Correct. He has to register and I wait for them to call me.
Okay. In addition, did you ever receive any copy of drug testing results from Mr. Hernandez that were ordered in that temporary order?
No.
You're also asking that any communication between you and Mr. Hernandez be through a co-parenting program, Our Family Wizard. Is that correct?
Correct.
In addition, as was granted in the temporary order, you are asking to keep your home address confidential and your employer confidential, as well as your phone number. Is that correct?
Correct.
Okay. You are comfortable with Mr. Hernandez using the email that he already knows for you that you're actively using. Is that correct?
Yes.
Okay. And why do you believe those protections are necessary to keep your home and employer confidential?
Because he has called me and confront me with things that I don't like.
And what are those things?
Well, like telling me that he's gonna go to where I live and do something that I'm not sure he's going to, but he's just been telling me that he's gonna go by my work and call immigration on people that are there and all these no nice things.
And how did you feel when you heard those communications from him?
Well, I was not expecting from him to do that because he knows my son needs me and why he wants immigration to deport me. You know?
In addition, you're asking for the permanent injunctions as we pled for in your original cross petition to be issued against Mr. Hernandez. Is that correct?
I understand that.
Okay. I'll pass the witness.
Ms. Khan, do you have any questions for Ms. Enzores?
No, Your Honor.
Okay, Mr.
Well-
Hernandez, I'm sorry, Ms. Khan, do you have one?
I was just going to ask, are you still in agreement with the $222 child support and the $50 medical support from the temporary order?
Are you asking me?
Yes.
Okay, can you repeat the question, please?
Are you still in agreement with the $222 child support and the $50 medical support as it was in the temporary order?
Yes.
I'll pass the witness.
Okay. Mr. Hernandez, do you have any questions for her?
Yeah, absolutely. So Mrs. Ansouris, just a couple of questions, and remember, you're under oath. You just testified that you didn't know anything about my DWI. Is that correct?
Correct.
Is it true that I gave you a ride from near your neighborhood to your job on the beginning of June? I mean, January, around probably the 6th or the 7th of January. And I picked you up in our son. We took our son to school, and then I dropped you off to your job. Is that correct?
Correct.
Was that
Okay.
what year was that?
Oh, 2025.
Okay, so
This
last year.
January.
Okay.
Yeah, no, this January. Yeah, last year. I'm sorry.
It was just a few days ago?
No, I'm sorry. That was last year.
Okay.
So did you see me blow the machine? The machine started beeping. Did you see me blowing?
Yes.
Did you ask what happened if they gave me another one?
No, I asked I asked you, did you got a DWI? And you say, no, this car is not mine. This car is from somebody that let me borrow the car.
I think that you and I know that if those machines, and I'm saying you and I because you have friends that had that machine a couple of times already.
So you can't testify in your questions. You have to just ask
Okay,
questions.
absolutely. So
And just break them down if you need to.
Mrs. Ansouris, any other person that you know had that machine before?
No,
The name of Abraham Diaz sounds familiar?
I never seen him with that.
No, I said if you knew anybody, not yourself.
Objection, relevance.
Very relevant. No, it's a proper point.
Overruled.
So, you know those machines has cameras, right?
No, I don't know.
Okay, you don't know. Perfect. I mean, if there's any doubt, we know that because both of us, we are KBC.
Objection, he's testifying, no question before the witness.
Sir, make sure
I'm trying to. Okay, Mrs. Ansouris, are you TABC certified? Texas Alcoholic Beverage Commission.
Yes.
Do you know about alcohol levels and all that, right?
Yes.
Objection,
Okay.
she's not qualified as an expert witness if he's attempting to have her testify in that manner.
No, not at all. I'm just asking if she's licensed about and she took a course from a Texas Alcoholic Beverage Commission. That's the only thing that I asked.
Overruled. You can continue.
You claim that I was intoxicated one day that you pick up our son that he stayed overnight. Do you remember that day you dropped it home in the morning?
No, that they dropped him. Yeah, I dropped him at the morning, and then you ask him to spend the night with you, and I say yes, he can spend the night with you, but I had to pick him up at 1 because he has therapy. And when I went to pick him up,
let me to stop you right
you
there.
were intoxicated.
It was on a Sunday. That was on a Sunday.
No, because Fabian had to go.
Let's start.
Sir, you can't interrupt. Sir, you have to let her finish her answers. You might disagree with her answers, but you have to let her finish them, and then you can ask further questions.
Okay.
Fabian needed his shoe because he had to go to therapy. It was a Friday.
Just for the record, I never showed up drunk.
Sir, you don't get to clarify the record. You get to ask questions right now.
Okay. So
at some point you will get to talk, but right now you're just asking questions.
Okay, Ms. Ansouris, you claim that I was violent to you back on 2019. Is that correct?
Can you repeat the question?
You testified that I was violent, that I apparently hit you, allegedly hit you in 2019?
Yes, just like my face.
If I was so violent, why you didn't call the police? What is the report?
I did call the police.
What is the report?
I have a call. They call and they call me back.
Okay, and can you prove that? Can you present proof? Okay, absolutely. Bring it.
They might have that in records that I called them and then I hang up the phone when you leave the apartment, and then
Okay,
they called me back when I was hiding in the restroom because I thought you were coming back.
okay,
And then I told them that you left the apartment.
okay. And if I came back, why you didn't call the police again if I'm so
You,
violent?
you come back in the morning when you were sober.
Went to the car to smoke cigarette and came back right away. So why you didn't call the police again?
I was in my room, locked.
If I'm so violent, what you didn't feel threatened that I could break the door down or something?
I was in the room, locked, and you didn't do
Okay,
anything else. So
that's all right
I
then.
didn't.
So Miss Azures, are you sure that what day? Do you remember the day that it was? Not the date. The day the day that it was. What day of the week was whenever you left the house, the residence?
That was February 3rd, 4th,
I'm
5th.
talking about the day of the week, not the date.
It was a Sunday.
Sunday. February 4th. Sounds okay.
It was the first Sunday of February.
Okay, February 4th. You just say that it was February 5th. Okay. Have you ever been violent towards me?
No,
Have you ever been aggressive towards me?
no,
Have you ever sent a voice message with cussing me out, telling me things, being aggressive towards me?
yes.
Okay, so, and again, you're being aggressive towards me, right?
I was angry because you were
I'm not talking
unresponsible.
about how your mood was. You were aggressive towards me, yes or no?
Once, yes.
Once, okay. For the record, okay. I have a
No, for the
couple. I
records.
have a couple of them. Okay. Um, and again, how are you like to the court?
I'm sorry, was that a question to Ms. Anzores?
Yes.
I didn't understand the question. Can
Have
it
I
you
be?
did not
ever
either.
lied to the court?
You haven't lied to the court?
No, you, Ms. Ansures, have you ever lied to the court?
I give the wrong day. That's what you're talking about. That
No, I'm not talking about. I'm talking about in general. Yes or no? It's a yes or no question.
no.
Okay. So, and again, if I was so aggressive, if that day, whenever you pick up our son from the house, why you kept bringing him? Because I was sleeping on the first
Objection.
floor.
He's testifying. No questions.
Yes,
from
sir.
witness.
Ask her your
Okay,
question.
do you
I'll wait for her
remember
to
where I was
answer.
sleeping back then?
So
What
she
room?
never answered your question.
I'm sorry?
I believe she didn't answer your first
Yeah.
question because you kept talking. So
Like,
if
do you remember what room I was sleeping whenever you pick up your son?
What day?
What room was I sleeping
At what moment? At what
whenever
moment?
you said that I was aggressive towards you?
That day when you were drunk?
No. Allegedly, you're saying that I was wrong. So the day that you pick up your son and the shoe was missing.
You opened the door. I mean, I knocked the door, and it took a while for you to answer the door. And then suddenly you opened the door, and the door was open wide. And I heard Fabian saying, "My shoe, my shoe." So
Do
I
you
opened
remember the room where I was sleeping?
You were downstairs,
Okay.
standing there.
Okay. Do you remember about June where I was sleeping?
Objection. Asked and answered.
I
I'm sorry?
don't,
do you know, ma'am? It's a yes or no. If you don't know it, you can say you don't know. If you
I
know, you
don't
know.
know. I don't know.
So the last time that you ever pick up our son from the house, where our son was sleeping, in what room?
He was not sleeping. He was looking for his shoe.
No, Miss Ansures. What room my son or son was sleeping the last time that you picked them up? that he even was crying on the stairs because he didn't want to
Object-
leave.
Objection, I'm
I'm
gonna
just
say
saying,
as answered at this
so she
point.
can remember.
He was on an empty table, on an empty bed with no sheets, with nothing.
Okay, ma'am, he asked what room. Do you know what the room was? I don't know what
The
the different
room that
rooms in his house
the room
are.
that used to be his room.
Who's his? Mr.
His room.
Hernandez or your child's room?
My child's
Downstairs,
room.
upstairs, right, left. Do you remember the location of the room?
My child's room upstairs.
Okay. I mean, I know that I cannot testify, but
You cannot, sir.
Yeah,
You can only ask questions.
I
You're
know,
going to
I
get a
know.
chance later to testify.
okay. Do you remember way before June 2025, whenever your lawyer allegedly told you or let you know that you about my DWI, and I'm saying allegedly because you knew that you
Sir, please ask the questions
you
with
made
less
a phone call
commentary.
to me and start talking about the last time that we took our son to the doctor. The car didn't start it because I was drunk or I was drinking or something like that. Do you remember that?
Objection, vague. What's the time frame on this?
Well, she seems to remember. Do you remember this? Do you know what he's talking about?
Yes.
Okay, she
The car-
remembers. You can ask
the
the next
car
question,
did not
sir.
start.
Ma'am, all he asked is to remember, and you do. So, sir, you can ask your next question.
And we left up what car because mine didn't start it.
My car.
Okay. Couple of days later, we start arguing. Do you remember what you said? I believe it's on a voice message as well.
I don't know what to argue about.
You remember saying that's why the car it didn't start it because you were drunk and that machine doesn't let you start the car. So and that was way before June 2025.
Correct.
Correct. So and again, you lied to the court saying that you didn't know anything about my DWI until June 2025, whenever you already knew about my DWI on 2024.
Objection. Objection misstates the witness's testimony. She said she learned of it from her attorney. She did not provide a date that she learned it from her attorney.
Okay, well, I'm talking about
Stand.
before June of 2025.
You say the car was not yours.
I'm not talking about, do you remember saying yes or no? Because the car is mine.
At the
Sir,
moment
you
that
can't
I,
testify. You can just ask questions. If she didn't think it was your car, you can't now tell her it was.
Okay,
it was
yeah.
or it wasn't. I don't know.
Do you remember? So, and again, this is a yes or no question. Do you just lie to the court again, saying that you didn't know anything about my DWI prior June 2025, whenever you did?
I didn't like
Yes or
the
no?
car because you told me the car
Yes
was
or
not
no?
yours. The
Yes,
car
or
was
it's
not
a yes
yours.
or no question, Ms. Ansures.
I didn't lie.
Object
No,
again that it-
no, that's a no.
I object that it misstates the witness's testimony. He keeps saying she said June 2025. She did not.
No.
You said 2025, whenever you let her know. That's what you said.
Stand.
So, I mean, pretty much, I think I can establish there's a pattern of lying here. So, I have no more questions right now.
Okay. Does anyone have any further questions for Ms. Anzoris right now?
No, Your Honor.
No, Your Honor.
I guess Ms. Bunch, you may call your next witness.
Thank you. I'll call Mr. Hernandez.
Yes,
Mr. Hernandez, please state your name for the record.
Juan Jose Hernandez Arizmendi.
And it's true that this court ordered temporary orders where you were to be in supervised visitation, correct?
It is true, correct.
You did not register for those visitations, correct?
Correct,
You've had no supervised visitations with the child, correct?
correct.
You were also ordered to submit to drug testing by this court. Did you submit to drug testing?
No,
So at this time, you did not follow the order of the court to complete drug testing or sign up for supervised visitations with your son. Is that correct?
is that correct?
I'm asking you, is that correct? You did not complete the drug testing?
Yeah, that's correct. That's what I
Okay,
said.
understood. And you were also convicted of a DWI last fall, correct?
I played guilty for a deal. That was the plea deal.
All right, I'll pass the witness.
Okay, Ms. Khan, do you have any
How
questions?
can I ask? How can I ask
Let's
myself questions though?
You're going to get a chance, so we go in order.
Okay.
So just be patient. I guess usually, I usually do this at the beginning, and for some reason I didn't. So let me just do some housekeeping court items for y'all before Ms. Khan gets a chance to ask questions. The first is I am an associate judge, and you do have the right to a de novo hearing before the referring court. This is on Zoom, so as I said in the beginning, everyone should be mindful about that. Nobody should be recording this proceeding. There should be no audio recording, video recording, photographing, broadcasting, any kind of recording. And that includes people here on Zoom or people who may be watching on YouTube. Nobody should be doing that. We are having a hearing, obviously. And so even though you're in your homes or a car, should act like you're in court. And you're all doing pretty good with this. I have to say, you're staying on camera. I appreciate that. If you do, for whatever reason, have an emergency or something comes up, let me know and we can deal with it. But generally stay on camera. Please don't have side conversations with anybody who may be in the room or vicinity. We take testimony in court. So generally one of you gets asked questions at a time. Unless you have a legal objection, which you've seen some of those today, please don't interrupt the person answering or correct them. You're going to disagree. That's why you're having a hearing. But just wait till it's your turn to be asked questions. Feel free to take notes if anyone would like to do that, so you remember what you want to say. If you do have a legal objection, and as I said, we've seen some, just make sure you get my attention, say what your objection is, and then I'll make a ruling on it. If you are answering the question when a legal objection is made, whoever that is, please stop answering and wait till the ruling is made so you know whether to continue or not. Also, just be aware, not with the Attorney General's office. Obviously, I don't work with Ms. Bunch or with Mr. Hernandez. So anything that you've all discussed in the back, nobody is allowed to talk to me about it without everyone present, and they don't. So just because you've discussed things with the AG's office or with anybody, it doesn't get to me. And so you might be asked questions about things that you've already discussed. Technically, things from prior hearings have to be re-asked as well. So as you can tell already, we've had some testimony. Some of this is probably repetitive of things you've done in the past. But thank you all for just answering the questions again. This is how I get evidence. It's how your record gets built. And so just please continue to answer the questions and not get frustrated. It's just part of the process. People can't, it's called ex parte if they talk to me without everyone present, so they do not. And that is it. So we will continue. And sir, you will shortly get a chance when we're done with all the testimony. Since you don't have counsel representing you, you will get a chance to speak. It's a little atypical, but Ms. Bunch, if you feel things are worthy of objections, or Ms. Khan, she's usually before me, so I think she knows this. Feel free to make legal objections that you feel are appropriate, and we'll go from there. So Ms. Khan, do you have any questions for Mr. Hernandez?
A few. Mr. Hernandez, so are you still in agreement with keeping the child support at $222 a month?
Yeah, that's fine.
Are you currently working?
No. I don't
And
know.
also keeping the medical support at $50 a month?
Correct.
Why haven't you done the drug test that was ordered?
Has been a little bit rough. End of the year, I lost my job back in August, and pretty much I've been applying everywhere. Resources are limited, and to pay for something extra is not on my priorities right now. My priority obviously is to have a place to live, a place to, if that happens, and when it happens, for my son to be able to spend time with me, and that's my priority right now. Obviously, it might not sound as a good excuse for some people or a good reason, but yeah, like whenever the car is broke down and stuff like that, yeah, the money that is coming in for here and there goes towards food, towards rent, towards bills. I have no cable, I have no luxury, so yeah, that's the main reason why.
Okay, and is that also the reason you didn't register to do the visits through the DRO?
Absolutely. So if I cannot take the drug test, why I'm gonna register?
I pass the witness, Your Honor.
No further questions.
And sir, are you still on probation for your DWI?
No, ma'am.
Okay. Ms. Bunch, do you have any other witnesses?
No, Your Honor, we rest.
Okay. Ms. Khan, do you have any witnesses before I let Mr. Hernandez speak?
No, Your Honor, the state rests.
Okay, Mr. Hernandez, since you don't have counsel representing you, I'm going to give you a chance to let me know if there's anything you think I need to hear. Please be mindful of the issues before
Yeah.
me, and stick to things that are relevant to those.
Okay,
And you may speak.
absolutely. Yes. So starting, and again, Ms. Ansures knew about my DWI way before she testified, because I can submit, if necessary, a copy of the receipt whenever the interlock device was installed on my car. That was January 2nd, 2025. I picked it up and gave it a ride to her job and dropped her son on January 6th, January 7th, a few days after. She saw me blowing. She did ask me, and I said no. And she was like that. And I was like, yes, I got one. So she knew about that. And then she still drop off my son for me to take care of him. Whenever she claimed the we were sleeping downstairs, yeah, it was on a Sunday because I didn't have to work that Sunday. And I was with my son because sometimes she picked him up on Sunday, she picked him up late. So that's why I requested for that day off. So yeah, the shoe was nowhere to be found, not because I was intoxicated, but because I was rearranging the upstairs. I was cleaning the house, pretty much taking everything that it was there, as some pictures submitted by Ms. Ansures, where I ask if anything from that picture belongs.
Objection. The pictures are not admitted into evidence. He's referencing documents not in evidence.
Oh, well,
Just stay-
documents. A
well,
picture of that. Okay.
I'm going to overrule it, sir. You can talk.
Got it. Yeah. So, couple of items around the house pretty much, because like I said, I was rearranging furniture, rearranging everything on the upstairs. I got a different bed. We used to have a queen. I got a king size, etc. Obviously, everything it is everywhere. And my son came in, we were playing and all that. She picked him up, and I said like, "Hey, just don't step in." I told her that don't step in, and she didn't listen to me. I asked her to leave. She even I said, I will call the police if you don't leave. And then it's whenever she left. Now, I did ask her, and again, how can I put this? Well, now when the last time that she dropped off our son for me to take care of him, it was in June. My parents were not here.
June
And
of what
it's
year,
whenever-
sir? June of 2025?
Yes, on June 25. My parents were not here yet, and our son spent the night with me. Like we slept in the room upstairs. Then whenever she picked him up, we were having such a good time. Our son started crying because apparently he didn't want to leave, and she kept saying her mom, no, no, no.
Objection. Hearsay.
And
Dane, sir, you can't talk about out-of-court statements.
okay. So that was I want to clarify that. So then she stated to my parents that she was not going to drop him off ever again because probably I gave him something to make him sleep. If she was suspected that I would do something like that to our son, did she take it to the hospital to be evaluated? He was just sleeping, enjoying himself with me. So I don't know. Like I said, I think I've proven a little bit of lying pattern with a couple of things. I do have a voice message. That if the court and the other party wants me to submit, I can submit it, no problem. Whenever she insults me, is aggressive towards me and cuss at me, and that's aggression too. I mean, it's just a lot. Now, the night that she claims that I was aggressive towards her and that I put my hands on her, that was February 2020, before COVID, not 2019 as she states. And I came in from a night out with a friend of mine. I said like, let me please let me go through, and she just started pushing me until I left because the same thing. So why I'm going to put the hands on the son, on the mother of my son? So that's why I left. And then if she called the police, I don't know. And then, like I said, I left outside to smoke cigarette to calm down, and then came back. Now she said that every day I was using illegal substance, this case cocaine.
Objection misstates the witness's testimony. She said he would use it every day if he could, but she knew him to use it about 3 times a week.
Okay.
So
I
what are
don't
you
know. I
exactly
don't know.
saying, sir? I thought
I
he
don't
just
know
said she said he used it. Did you say a specific amount, sir?
No, like I didn't use. I did use it, but no. After
Overruled.
we
We can
stopped. We
continue.
stopped using it together. So because simple as this, I was the only one working on the household. I was the only one bringing income. And having a habit like that is very expensive of the amount that she claims the I was using it. So how if she didn't work, how if she didn't help the household income, how could I afford paying a full house and everything and still buying illegal substance like every day or every 3 times a week or whatever? And she claims that I'm still using it. So it's like it doesn't make any sense because, like I said, she wasn't working. Now, I did ask her a couple of times throughout the relationship to help me out. Like, hey, can you help me out, please? On getting a job. Never. Not a problem. I said,
Relevance.
Sir, how is this relevant?
It's to prove a point. It's to prove a point. I swear.
What point?
Whenever she said that I kicked her out.
Objection misstates the witness's testimony. She didn't say he kicked her out. She just said they separated.
Yeah, sustained.
Okay.
I'm
Whenever
going
we
to sustain the
separated,
first objection as well.
I'm sorry.
I'm going to sustain the first objection as well. So
Okay. Whenever we separated, it was the relationship. She claimed the relationship was over on February 4th, 2024. The relationship was way over before that. We were living as roommates because she was sleeping on my son's room since 3 or 4 years prior, and I was sleeping on my room. So pretty much we were roommates. And then something happened back in November. Magically, after so many times asking her to help me out, and then she decided to get a job and just basically for herself. So I believe that she had all that planned, well, with everything that had happened. So that's just my side of the story. Like I always said, there's always 3 sides of the story: George's right and the truth. I mean, that's it. Because, like I said, first of all, she did know about my DWI prior, when she testified that she got notice about it. Now, talking about the DWI, yes, I plead guilty. But that doesn't. But that I didn't spend no time in jail besides the first arrest. Then back on March, if I'm not mistaken, the machine got a malfunction. Obviously, that's not stated on there, but I can bring proofs if they want me to. The machine had a malfunction, and it gave a false reading whenever I took it because that what triggered basically the motion for get my bond revoked. Whenever I went to court, it was proven the machine had a malfunction. So that's why I didn't get arrested and my bond was not revoked. I just want to make that clear. And pretty much that's it.
all right, what are you asking for?
Well, first of all, again, we'll get to the point that I will submit if necessary, and that's the only way the Mrs. Anzures will agree to let me see my son. I will submit the drug test, but not because not because she asked the court to do it. It's because I can prove this to my son and to myself, and not to her first. Second, I'm not signing anything that it says that I'm a violent person because that's what she stated, and I am not. If we're gonna talk about violence, she's violent too, so I can countersuit if that's the case. I don't want to do that. Like I said, I always said, and I always told her and everybody else, we could have our differences, but she's a good mother. and I never said otherwise. So that's the two things that I don't really agree. Everything else. Oh, and also I would like to stay on the decisions of my son. I mean, sometimes we take a couple of decisions that it should be probably better talk to the parents on both sides instead of just one. I mean, sometimes whenever only blindsided for one side, that's the only three things that I don't agree with. She can stay. She can stay as custodial parent, no problem. She can decide where our son is going to live, no problem. Pretty much everything else besides uh, life decisions, I'm not signing that I'm Biden because I am not. There's no proof of it, and pretty much, if there's proof, I can. And again, I can submit the voice messages and stuff like that she had left throughout the separation, and yeah, pretty much. Just next time, no, like I wish that since the very first hearing, there would have been no lies. This would be so over and done with. But
Okay.
people sometimes we make dumb decisions, like mine whenever I was drinking. And the main reason why I had that accident is because I was working 16 hours a day on round top. I was leaving the house at 9 a.m., coming back around 1 or 2 a.m. every day for 3 weeks with only one day off. So that's the main reason I fell asleep, because not because I was intoxicated, because I was tired.
Okay, Ms. Bunch, do you have any questions for Mr. Hernandez after his
No, Your Honor.
testimony?
No,
I'm
Your
sorry?
Honor.
Okay. And Ms. Khan, do you have any questions for him?
No, Your Honor.
Okay. I'm going to take a moment to look at the documents. Okay, does everyone rest?
Yes, Your Honor.
Yes.
Mr. Hernandez?
Yes.
Okay. I'm going to render judgment. I'm ordering that Ms. Anzores is the managing conservator and Mr. Hernandez is the possessory conservator, with Ms. Anzores having the right to determine the primary residence of the child within Waller and contiguous counties. For the visitation, I'm ordering what's in the temporary order, but I'm making a few changes. So the initial period will be through the supervised Harris County Domestic Relations Office, but with the same parameter that once he gets a clean drug test, he can move to that next phase. So it's going to be phased in with that drug test. So that part is the same. Then once he gets to that next phase in the temporary order, the 1 to 5 will be for 5 periods, 8 to 5, 5 periods. The next phase, the 6 to 6, will be for 5 periods. And then before he gets to a standard possession order, he has to take another drug test. If he passes that drug test, he moves to the standard possession order. If he fails the drug test, back to the stage 1 DRC. If he refuses to take a drug test, back to stage 1 DRC until a clean drug test happens. Does that make sense?
Yes, Your Honor. I just want to clarify for the drug test, is it a urinalysis and a zero tolerance hair follicle, or a different?
Yes, the same one that was ordered in the temporary order. So yes. The medical support, I'm approving the agreement and finding that Ms. Anzores is providing insurance through a government or medical assistance program. I'm ordering that she continue that program, and Mr. Hernandez is ordered to pay Ms. Anzores $50 per month cash medical support beginning November 1st, 2025.
I'm sorry, Your Honor. That's to Mrs. Anzores or to the state?
It's
The
technically ordered to Ms. Anzores. As a practical matter, the state usually keeps it as long as the child is receiving that benefit.
Okay, thank you.
Child support, if she somehow, for whatever reason, is not on the government or medical assistance program, she will need that money to pay out-of-pocket expenses anyway, because she will
Okay,
have
that's fine.
insurance at that point.
Yeah.
And so someone has to provide something.
Yeah, absolutely.
I'm ordering you, Mr. Hernandez, to pay Ms. Unzura's child support of $222 per month beginning November 1st of 2025. I'm approving the agreement that there'll be no back child support. That's part of the agreement. I'm denying any family violence finding, but that's not going to be in the order. I am granting the non-disclosure for Ms. Unzura's. And at this point, app close, I think, is what we used in the temporary order. They now charge. So do you all want to, talking parents, I believe, is still free. Don't know for how long.
I was going to propose Our Family Wizard. They have the easiest fee waiver program to apply for both parties. I think they both.
Okay. So I'm happy to do that. You should both understand that you'll have to apply for the fee waiver. Ms. Bunch, do you know if you're able to do it online?
Yes, they can do it online.
Okay, so if you go to Our Family Wizard, Mr. Hernandez, I guess your attorney can explain it to you, Ms. Unzura's even better than I am. There is, if you Google fee waiver, Our Family Wizard, something should come up. I have not done this myself. And according to Ms. Bunch, it is easy. So make sure you apply for that. Otherwise, there will be a fee for it. Little by little, the free apps are going away. And I guess I'll even say you're each ordered to apply for a fee waiver to encourage it. And I think that covers everything.
Let me just confirm on the injunctions that they are granted.
Oh, yes. Okay. I'm going to continue the mutual injunctions to both of them. Everyone should be behaving. Although I think I have to get rid of number 9, the canceling or altering payments for insurance.
Yes, so it asked to remove that.
Yeah, because people might have to change insurance, and I don't want to prohibit that from happening.
Yes, that, and if we can remove the school one as well, just because my client may need to progress.
Yeah, exactly. As the ages, that's going to change as well. So yeah, okay. So what we're leaving, just so everyone knows, intentionally communicating with the other person, including telephone or electronic ways, using vulgar, profane, obscene, indecent language or offensive language. So neither of you should be doing that. You shouldn't be taking unlawful action against each other, or threatening to take unlawful actions against one another. Don't threaten each other. Using phone calls in offensive or repetitious manner, or to harass the other person. Nobody should be causing bodily injury to each other or a child. Threatening each other with bodily injury. No one should be doing that. We're going to get rid of withdrawing the child because kids have to change schools and things happen. Nobody is ordered to make disparaging, everyone's required to not make disparaging remarks about the other person or the person's family, other parent's family in the presence of the child. The child loves both of you. You're both the child's parents. So just be mindful of that. You all obviously had a rocky relationship, and that's okay. But just now going forward, you're co-parenting, you've separated. And so you all have to appreciate that your child is part of both of you and loves both of you. And so just be mindful of that, and don't say bad things about the other parent before the child, because it makes them feel bad. That child is part Mr. Hernandez, and he's part you, Ms. Unzura's, and he knows that. What else is in here? I just lost the screen.
I have a question.
One moment, and the last one is allowing the child to remain in the
you.
presence of someone who's making disparaging remarks about the other party. So if you have a friend over who's like, "Oh, Miss Unzura, this is terrible," like, just again, he loves both of you, so neither one of you, should be supporting it. And I know that you have this hurdle to get over, Mr. Hernandez, but once you do, you're going to be in his life again. Okay. What was your question, sir?
The communication, does that include family members? Because it's my understanding that Mrs. Unzura still talk to my sister-in-law. I just want to make sure, what extent is the communication prohibited or allowed?
It is allowed. I'm not prohibiting people from talking to people.
No.
And let me just say, if harassment happens to anybody, sisters, brothers, each other, nothing in this order prevents you all from going to police, calling CPS. Like, if you think bad things are happening, you can address them still. This order doesn't say never call CPS. Like, if you think your child is being abused, by all means, deal with it. If your sister-in-law or your sister thinks she's being harassed by anybody, she's free to deal with it. But at this point, I have not heard any evidence to restrict Ms. Unzura's communication with anybody.
Okay.
I'm not really restricting your communication with Ms. Unzura's. I'm just restricting it from being inappropriate.
Yes, no, I completely
And I'm giving you that app tool because it does allow, if you claim she's being rude to you, if all of her communication is in that app, you're able to print that out, give it to a DA, give it to a police officer, give it to a judge to prove Miss Anzares is harassing me. I need a protective order or whatever you need. And so it should hopefully it will keep that from happening, which will be good for your child. And hopefully if either of you, people get mad, your first instinct is I'm mad at Miss Khan. I'm going to send her a mean email. But maybe if you realize, oh gosh, this is going to be shown to somebody like a judge or a DA or a police officer, maybe I shouldn't send that. So maybe that's just one more thing to remind you all, like, in addition to all the other good reasons to be nice to each other, or decent, at least pleasant to each other, what you're writing is there forever. It can be printed. That's the whole point of these apps. And so you all should be mindful of that, just so that you can all, not get in trouble.
And last question, can you, to what extent Ms. Ansur is still using my membership from Sam's Club? I've asked her not to it and all that.
That is going to be between you. That's between you two. That is not before me. If you need to take legal action about that, whatever that action would be, you're free to do so.
Thank you.
This is, I can't remember what kind of, was this
Just a question.
no, this isn't a paternity case. Are they married or?
No.
Not married.
Okay. So yeah, that is between the two of you and Sam's Club. It's not before me.
Okay, no, that just wanted to know. Thank you.
Okay. And thank you all. Ms. Khan, do you want them back in breakout rooms or circulate the order, or?
I think we can. I believe Miss Bunch are you preparing the order? She's already got it mostly prepared.
Yes, I can finish preparing it.
Okay. And we can let everybody go, Judge. I doubt Mr. Hernandez will sign anyway. I mean, we'll send it.
Be sure to send him a copy though.
I'll send it.
I can read it and then I can sign it.
Yeah, I mean, if you agree to it, sir, by all means sign it. If you have something specific, should we set this for entry just in case? Where are we? January?
Just in case.
I mean, I want to give you a chance to review it, sir. And if you disagree with the drafting, you're free to come or should we set this for entry on February 19th for our next docket? It can be by Zoom. If you all sign off on it in advance, so Mr. Hernandez, if you sign off on it and everyone signs, no one has to come that day, even on Zoom. Okay. But if someone disagrees with the drafting and you'll want to have me decide it, it'll be on Zoom that day, February 19th at 9 a.m. on Zoom, same Zoom code. Will that work?
Thank you.
Yes. And if you circulate it in advance and everyone signs it again, no one needs to show. I won't be offended. And we'll just go from there.
All right, thank you very much.
Thank you, Judge.
And this is a suit for modification of support order filed by the Attorney General's Office October 29th, 2025, involving Daniel Ray Colbert and Jennifer Gail Hine. Ms. Hine, can you state your full name for the record, please?
Sure, it's Jennifer Gail Hine Gaskin.
Okay, thank you. And Ms. Parham, can you state your full name and who you represent?
My name is RJ Parham. I represent Daniel Colbert.
And I'm sorry, what was your new last name, ma'am?
Gaskin.
Okay. And ma'am, do you have counsel?
I do not.
Okay. If you can raise your right hand to be sworn in. Do you solemnly swear that any testimony you give today will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can lower your hand. And counsel for the Attorney General's office?
Yes, I'm Brian Hostetler with the Office of the Attorney General.
Okay, and where are we on this matter?
Your Honor, as you mentioned, this is a suit for modification of child support order. We are asking for a reset today. The other party, the father's attorney, will be asking for a temporary order in place. Mr. Colbert is in prison or is in jail currently, and we are asking for a reset to give time to reevaluate what his status is going to be in the future.
Okay, and there's no agreement, I guess? This is in
No,
dispute?
no, there's no agreement. We do not wish to reduce child support temporarily at this time.
Okay. Does anyone have anything else they'd like to add in summary of what's being requested?
Not as
Barnes?
far as what's being requested, Judge, but there is something I want to call to the court's attention. This suit by the Attorney General was filed October 29th. I believe it was December 9th in the county, and it was filed in the county court at law under the county court at law cause number. On December the 9th, the county court at law signed a motion to dismiss that is completely unqualified as to which actions it's trying to dismiss. There were 3 pending at that time.
Oh, Mhm.
And it was unclear to me that this suit was even still pending. The other thing is I have documents that I want to present that should be self-proving as public record and official government records that will show he's entitled to a reduction of child support at this time.
Okay, one moment. I had this up all morning and then I took it down because I was closing other cases. So I did see that notice. There is a notice before the court dismissed that case, because I agree it doesn't say what was dismissed. There is a notice of intent to dismiss for want of prosecution that the court issued on October 31st, 2025, days after the AG's office filed their pleading. And it said, the petitioner's motion for enforcement of geographic restriction and possession and access has been inactive in excess of a period of 6 months. The case will be dismissed on December 5th unless a motion to retain and request for setting is received. Motions to retain without a request for setting will not automatically be granted and are set for hearing on December 5th. And then on December 5th, it got dismissed. So I'm fairly certain it was the enforcement of geographic restriction and possession and access that got dismissed, although could be more clear. So I do believe this action is still pending here. As for documents, Mr. Hustle, do you have a copy of the documents? Have you all discussed
Yes,
the documents?
yes, we've received a copy of the exhibits.
Okay. And I don't know if you've discussed this in the back, but does everyone agree to admit them, or is there dispute on that issue?
No objections to admit those.
Okay. And Ms. Hine, do you have any
No objection.
Have you seen the documents?
I have not.
Okay. We need to make sure she gets a copy of the documents, and then I can create a case center link like I did in that other case. I don't know if you ever signed up for that, Mr. Hostetler. Maybe Ms. Khan can, or I can try to set it up in a way where I just email you. So give me a moment to do that.
Okay, while we're going there, Judge, I have no way of getting Ms. Hine the documents. The AG, I'm assuming, has a means by which to contact her.
That's correct. I'll be emailing her
Thank you.
with the email we have on file immediately.
Okay, just bear with me a moment while I get this set up. Mr. Hustle, do you have any exhibits you're going to be admitting?
Just the pay record, if it comes to that. Okay. And also if we...
Isn't this just a motion to modify? Did you also ask file to confirm arrears?
No, Your Honor.
You are correct, Judge.
You're correct. So that doesn't need to be admitted.
Okay, I've seen them.
Okay, bear with me one moment.
Yes, ma'am.
Mr. Hustle, you should get a link in your email very shortly asking you to upload exhibits. And you can whoosh them in there and click upload and it should work.
Do I need to click the restricted checkbox or just
Completely.
drag? with
I
that?
think you can just drag and then upload. But I could be wrong.
And I haven't. So are you uploading my exhibits?
Yes.
Oh, okay. Should be a total of 4.
They're uploading. And Your Honor, we have a child support officer who we could call in to testify about Mr. Colbert's income. However, because we do not plan on moving forward with a final order today, we have not brought her in. But we are prepared.
It's up to you what witnesses you do or don't use.
Okay.
I can't give you legal
Okay.
advice.
I know. I was just informing you.
And I don't know enough to even give legal advice if I could, to be honest. I'm aware a little bit for what you told me, but I'm a little curious with him being in jail where this is going.
Okay. I have an indication that 100%
Went through?
has been uploaded.
Okay, let me check the logistics on that. Okay, I see 4 exhibits are uploaded. So I think we're ready to proceed. Who would like to begin?
Judge, they're pleading as far as substantial and material change. So
Yeah, they pled for it.
Oh, I'm sorry. Yes, Your Honor, we filed a motion for that there had been a material and substantial change at the time. Mr. Colbert's salary had raised significantly, and Mrs. Hine had began to pick up medical insurance that was originally covered by Mr. Colbert, and we sought to move forward with a modification. Mr. Colbert was arrested in September 22nd, 2025. That does not meet Texas Family Code 156.401 C1. That requires 180 days. That requires incarceration exceeding 180 days to have a material and substantial change of circumstances. So it is therefore we would like to reset to get a better understanding of what Mr. Colbert's future is.
Okay. Ms. Parham?
yes, Judge.
And then it was deferred after he served his time.
Objection, Judge. You don't do deferred probation after you've served time.
He
That's
did
a Texas impossibility.
he did weekend jail
Objection,
time.
Judge, please.
I actually think this helps your case, Ms. Parham, but how is this relevant, Mr. Hostetler?
His job,
What
he was able to continue his job. His job was not affected
Yes.
by this.
By this, yeah. He was still able to work during the week and he served time on the weekends.
is he currently serving time on the weekends?
No,
No.
he's not.
Okay, so it's a different scenario completely.
It was a different case. Yes.
Okay. I'm going to sustain her objection.
Okay. Has the circumstances surrounding the children's medical insurance changed since the divorce?
Yes, he was supposed to be carrying it, and he was, and it wasn't covering very much, so I had to do sub. I guess adding our insurance to it, so we'd have double coverage. Then in October, there was no coverage anymore, so I'm still continuing to pay for the insurance for the kids.
What is the current medical support cost?
For the kids only, it's $375 a month.
And for dental?
It's $23.
What is your knowledge of Mr. Colbert's assets?
To my knowledge, he still has a
Objection,
vehicle.
Judge, unless she has some personal observation that she's fixing to testify to that is current since the arrest.
Since I believe you can testify regardless, but please can we be more clear as to what
Yeah.
her personal knowledge is and what she is testifying to?
Yeah.
So I'm going to overrule the
Ms.
objection,
Hine,
but if you
can
can
you please
clarify.
testify your personal knowledge and including dates and times of when you received this knowledge?
At his last pickup with the kids, which was back in September, he still had a vehicle that he was driving to pick up the kids.
Okay. Do you know of any liquid assets or bank accounts that he currently has?
I do not.
Or any savings accounts?
He has a 401k when we were divorced.
Does he have any other vehicles that he owns currently, to your knowledge?
Not that I know of.
Thank you. Do you understand that the Attorney General's office is going to be asking for a reset
Yes.
today so we can reevaluate in the future to see what his status is?
Yes, sir.
Thank you. No further questions, Your Honor.
Okay, Ms. Parham, do you have any questions for her?
Yes, Judge. So after your divorce required or stated that you were not to leave the state of Texas with the children. Is that correct?
I'm going to go back to the OAG as far as legal issues, Ms. Parham.
How is that relevant?
It's a substantial and material, it goes to her substantial and material change in what the insurance was not covering. That there is.
I am currently in Texas with the kids.
And have you filed that address change with the court?
It has always been with the same address. I have property here in Texas.
Do you recall a hearing that we had in this court where you admitted that you lived in Louisiana with your current husband?
I have property here in Pattison, Texas, and we also have property in Louisiana. We were split time between both properties.
And at the time that we had the hearing in the county court at law, your children were enrolled in school in Louisiana, correct?
That is correct.
And you were voting in Louisiana?
And I was told to come back and bring the kids back
Were
to Texas.
you voting in Louisiana?
And I did. No,
Judge,
I did
may
not.
I ask that you instruct her to answer my question?
Yeah, ma'am, if
I
you
did
can just
not
listen
vote.
to the questions. Ma'am, if you can let me speak. Please stop interrupting people. And if you can, right now you're on the witness stand. Mr. Hostetler's going to get a chance to ask you more questions. And then since you're representing yourself, you'll also get a chance to speak at the end. But right now you're on the witness stand and you have to listen carefully to the questions and just answer the questions asked.
Okay.
And if someone's speaking, wait until they stop. Okay, Ms.
Thank you.
Farm, you may continue.
Thank you. And at the time we had that hearing, your children were enrolled in school in Louisiana, correct?
Yes, they were.
And your driver's license was in Louisiana, correct?
No, it was not.
It was no longer in Bryan College Station, which is where you resided at the time the divorce was granted, correct?
It was in Pattison, Texas. I kept my property here in Pattison, so my
My
driver's
question was,
license.
what did your driver's license say, not what property you owned?
It has Pattison, Texas
Okay.
as my
And
driver's
the-
license.
And the medical insurance that you're saying didn't cover the medical expenses, those medical expenses were incurred in Louisiana, correct?
I didn't say it didn't cover them. I said it didn't cover a lot of them. It
And
covered
those
some.
those expenses were in Louisiana, correct?
They were both in Texas and Louisiana. Yes, ma'am.
I have a question. Maybe I misunderstood. Is there right now the current insurance for the child? It's just through you, ma'am, right? Dad is no longer providing it.
No, from my understanding, through the insurance company, he is not providing insurance for them.
So yes, Judge, you are correct. It is strictly
Okay.
through her.
Okay. Do we know why?
Have you received any kind of notice regarding Cobra on his insurance?
I have not.
Have you received any notice that the insurance is no longer covered?
No, other than I called the insurance company because they keep denying claims.
And you said you got that confirmation in October.
Yes, after I had filed for the substantial change.
And you did not have any indication from your insurance carrier that there was another carrier that had insurance when you applied, correct?
State that question again.
When you applied to take over the insurance,
Mhm.
you did not receive any kind of notice that there was another company that had insurance on the kids, correct?
When I applied for my insurance on the kids,
After October.
I continued my insurance. I've had insurance on them since 2021. Sorry, excuse me, 2022.
But now
insurance.
your insurance is the primary insurance, correct?
Yes, correct.
And
Since
your
October.
insurance company has acknowledged that the previous insurance is no longer covering the children.
Yes, they are both, insurance are both through Blue Cross Blue Shield.
Do you have any knowledge at all regarding what was used to pay for the bond that was originally set by Grimes County and revoked and turned into the $500,000 bond?
I'm not sure what you're talking about.
I would pass the witness, Judge.
Ms. Hostetler, do you have any other questions for her?
Yes, Ms. Hine,
Mm-hmm.
in your divorce decree, you were awarded sole managing conservatorship,
Yes, correct.
and you had no geographic restrictions placed on you as your primary residence.
So when we moved to Louisiana, my papers that I had in hand said that there was no geographical restriction. From my knowledge, when I spoke to my lawyer and she had confirmed at that time, there was no geographic restriction in the
Objection,
divorce
Judge.
decree.
The
I'd like to
final
finish.
Objection,
No, ma'am,
Judge.
ma'am, she's allowed to make legal objections. So
Okay.
wait till she makes it and then I'll make a ruling. What is your
Okay.
objection?
My objection, Judge, is that she is referring to an order that was replaced by a nunc-pro-tunc order.
Correct.
The final order and the original rendition required a geographic restriction.
So that's what I was going to say.
I'm
The
overruling the objection, but Ms. Hostetler, maybe you need to clarify your question.
So yes, just please answer. Was there a geographic restriction in place?
so in
And I'm just going to stop everyone.
Okay. This is,
Um,
it's a long
No,
debate.
ma'am, please give me a moment to collect my thoughts and explain why I'm
Okay.
stopping you.
Okay.
I'm not stopping you all from going down this road, but I'm stopping you from giving me the historical history of your case. It
That's,
really
yeah.
doesn't, and I don't mean to be rude when I say this, but it really doesn't matter to this issue how you got that restriction. If there's now one in place through a nunk-pro-tunk, I just want to know there's one in place. If there's
Okay,
not
there's
one in
one.
place, I want to know there's not in place. But I don't need to hear the gory details of how you went back to court and fixed the order, blah, blah, blah. Like, it's not relevant to this, and we don't have time to do
Okay.
that. Okay, does that make sense to everyone?
Sure,
So
sure.
feel free to still go down this path of what you're all arguing, but let's try to make it more relevant to the future,
So,
the present.
okay.
Was the payment of child support pending your geographic restriction?
I'm not sure what you're asking.
Was there any stipulation of child support being based on your geographic restriction?
No, there wasn't.
Thank you. No further questions, Your Honor.
You,
You may proceed.
thank you. You had made the statement earlier that you received child support in October and November,
Mm-hmm.
and those amounts were $217.69 each one of those 2 months.
No. I think OAG, you have the amounts that were paid. I got a full payment in October.
Judge, may
Let me
I?
just say, at the risk of doing something very not judicial, as someone who works for the state, they pay you for the month you worked. So if you work the month of September, the paycheck comes in October 1. So
Okay.
that could be why. But I don't know about November.
Okay.
So,
Yeah.
Ms. Carr, what were you going to say?
I was going to request that the AG upload their pay exhibit in order to show the conflict between the testimony of Ms. Hine and their records.
Yes. Your Honor, will we be able to submit a pay record?
You can, yes. Give me one moment to add you to the master bundle as a separate thing. I did not have to do that. Okay, let me give me one moment.
That is a substantial and material change. He cannot bring the suit till he's been locked up for 180 days. But if the suit is brought, then his income and his resources after 90 days has to be considered while he's in custody. And we ask for that consideration so that he doesn't come out of custody in horrendous arrears because he's been locked up by the state. I suspect that's why those provisions were modified from the family code prior to them being put in place. So we're asking for temporary orders. It's my understanding the earliest date that the court can go back to is the date that this modification was filed, which I believe is October 29th of 2025. That should relieve at least November forward until such time as he is no longer incarcerated, whether it be from a plea that puts him out on probation or he has satisfied whatever sentence that he either pleads to or is assessed by a jury.
Does anybody know if there's a trial date? And I know it might change, even if there is.
There is no trial date currently. We do have status hearings in both counties, one day apart in February, but it's status hearings.
So I know one that was filed in Grimes. Where's the other one pending? Is that
Austin County.
Austin, okay.
Which is going to be your Exhibit 3.
Okay.
He had one pending in Grimes when he was picked up in Austin County.
Okay. So he was picked up in Austin on the lesser charge, and then the greater charge.
Grimes County came back and said, hey,
don't let him go. Yeah. Okay.
So now you've got a $500,000 bond in Grimes County.
Okay, I'm going to make my ruling and render now. I am going to order a temporary order, so some of this can get sorted out, although I don't know if it'll get sorted out because sometimes these criminal cases can take a very long time. But at this point, this is a very unique circumstance. The AG's office filed thinking one set of circumstances occurred, and in reality, something else was happening. They thought he was gainfully employed with TxDOT and making more money, when at the same time, he actually, I think literally at the same time he filed, he was actually in jail and no one knew. Maybe they should always run names through jail. I don't know. But it happened. It was an accident, and this is where we are. I agree with you, Ms. Parham. I don't believe they could have filed for jail until that 6 months passed, or done it administratively, which they now can do. But we're here, which is unusual because you're not usually here before that 6 months. But we're at 4 months already, and he's being held on a $500,000 bond. So I am going to find, in addition to the testimony of Ms. Hine, I am going to find there's a material and substantial change in that he is now incarcerated, and there's just no testimony. And I also find it incredulous that TxDOT would still have him on the books 4 months in, unless he has a lot of leave built up. Maybe he's taking leave this whole 4 months. That is possible, I guess. But I've heard no testimony that he does have leave built up and he's still getting a paycheck. I guess the state can look into that before the next setting. But at this point, I have no reason to believe he's still working because he's in jail.
And you do have an affidavit from him saying he has no income.
And there is that affidavit. Do you know if he was found indigent?
He was found indigent in both counties, and I was appointed to represent him in both counties.
Okay. So he was found indigent, and there's no testimony that he is still working. So I am finding there's been a material and substantial change. I can only modify child support to date of service or appearance. And I actually think your appearance today, Ms. Parham, is his first appearance in the case. I don't believe he actually got served. And I'm guessing it's because they probably tried to serve him at his home and he was in jail. So I'm going to modify support and order him to pay Ms. Hine $0 based on actual resources, because that's the only testimony I've heard, as well as 154.123, which allows me to consider additional factors. And those factors are that he is now in jail with a $500,000 bond. So I'm going to order it starting at $0, beginning February 1st of 2026. I'm going to find that Ms. Hine is now providing insurance. I'm sorry, was she also providing health, dental insurance? Yes, she's providing health and dental. And so I'm ordering her to provide those, at least temporarily, with a $0 cash medical as well. And gosh, I don't even know when it's, I hate to say worth because that's not a good way to describe this, but unless he pays the bond, I just don't see it resolving soon. What reset date were you proposing, Mr. Hustetler? I don't want to waste people's time coming back unnecessarily, but I also don't want to, if he does pay that bond, I don't want to ignore this. Or if he does go to trial and be found and not committed to jail, and I also don't want to belabor it.
4 months out works, Your Honor.
Yeah, and luckily this is a recently filed case, so we have a little breathing room.
May 14th.
Everyone available on May 14th. It'll be Zoom again.
Can you tell me the day that is on?
It's a Thursday. We're usually on Thursdays. You have one of the rare Fridays.
I work that day. I can't afford to take off.
And Judge, as it currently stands, I am in on the jury trial list in the 506th in Waller County I haven't updated my last docket, but before my last docket, I already had 3 cases set on that trial docket.
June 18th.
Would June 18th work any better?
What day is that?
Let me look.
It's always a Thursday. What days
If
are
I'm
you
getting-
available, ma'am?
Yes,
On
June 8th.
Friday. Fridays are my days off. And honestly, since I'm not getting any child support, I'll probably be working on those days too.
June 18th is available, Judge.
I mean, do we need to pref set this on a Friday?
Preferably, yes.
Mr. Hustle, do you want to
Yeah,
finalize this and then file a modification if you learned he gets out of jail? I guess I don't.
Uh,
Yeah, because I can only accommodate so much.
Yes, Your Honor, that's the Attorney General's office would like Ms. Hines' input on this before we.
I do have the option of finalizing this, and then if he gets out of jail, you can let them know and they could file to modify again, because that would be a material and substantial change in circumstance. Or we can reset this. I could try to prep set this on a Friday, but I can't guarantee it'll get resolved at the next setting. I will say the legislature has given us a year to resolve cases now. So at some point it will have to be finalized and it will stop regardless of whether this all gets fully resolved or not. If that makes any sense.
We can set it for June. Preferably on a Friday though.
Well, I was going to offer Montgomery a Friday, but now she's taking it, guys. So that's where we are on that. I guess we can pref set this. What about yes, June 12th? Can you all do that?
No.
No.
I am back in trial. That is another trial week for the 506th in Waller County.
Okay. What about May
I've got-
20?
I've got the 5th and the 26th. The 19th is actually a holiday.
Yeah, exactly. Between holidays and stuff. What about May 29th?
I am open.
May 29th is a Friday.
That's fine.
We'll prep set this on Zoom. What time, Ms. Parm, do you want us to prep set it a little later so you can do docket calls?
I thought this was May 29th.
I'm sorry, May 29th. I don't know what I just said. Would you like us to prep set this a little later so you can do docket calls?
I have nothing on that date right now.
Okay.
So you'll be the first.
Okay. We can do 9 a.m. On May 29th. It'll be. And we'll go from there. Okay. So temporary order today with the reset date. For that date, it should be pretty fast, Ms. Hine. If you do need to work or do other things that day, I can't promise it'll be quick, but at this point, we don't preface it that many cases. So it shouldn't be a full docket where you first have to wait to be heard. It will probably just be your case. Maybe one other will get set, but it's not a full docket day.
Okay.
So it should be quicker, and Ms. Parm, you can be aware of that as well. I don't think it will take as long that day, but never say never.
I learned that a long time ago, Judge.
Yeah. The moment I say that, something will happen. And yeah. Okay. So Mr. Hostetler is going to draft the order and we'll reconvene on that day and see kind of where things are.
Thank
All
you.
right. Thank you.
Whatever evidence there is. Okay. Thank you.
Thank you, Judge.
Thank you. And we can stop the recording and the YouTube.
And
Ms. Hines' partner, if you want to go into breakout rooms, I'll be happy to talk to you then.